appreciate you joining us today. My name is Eric Boughman, and I'm with the law firm of Forster Boughman, Lefkowitz & Lowe. And I am joined by my colleague, Skip Sell. Skip, can you say hello to our audience?
Good afternoon, everybody.
All right, so today we are talking about really a hot button issue here in Florida. And I'm really excited to talk about this because I think it's something that we're going to hear more and more about over the next several months, even maybe going into next year. And this is ADA compliance for websites. And so the title of today's seminar is your website ADA compliant? And we're actually going to cover this over a couple of webinars. We're going to do a series over the next, those who have joined us for webinars in the past know that we just finished up a long series on asset protection that went for a little over a year. We wrapped that up last month. And our next few webinars, including today, are going to deal with website and internet compliance issues. So today we're talking about ADA compliance. We're going to do some broad overviews today and just give the audience an idea of what the issues are and some takeaways today on how you can take some corrective measures to protect yourself. Next month, we're going to come back because we're going to skip over a lot of details today and just brush with some broad strokes. And especially the lawyers and some of the professionals in the audience, maybe even some of our technical people, may want to hear more details, and that's what we're going to cover next month. So next month will be a deep dive into some of the more interesting nuances of where we see the law and the technology issues as they develop. And today's agenda is shown here, and we're going to talk about first the background of the ADA in the 21st century, and that's really what brings us to the internet issues. And we'll go over web accessibility and the recent legal developments, including some recently withdrawn government action, and then the consequences if you are not in compliance, how to achieve compliance, what happens if you get sued and how to mitigate your downside in a lawsuit. And then hopefully we'll have time at the end. We'll cover some other just random issues and talk about a law that's actually pending right now and could become law maybe over the next year, year and a half. As we go through the webinar, I'm able to view questions that you pop into the GoToWebinar screen. And so we would encourage you throughout the webinar, if you have questions, please drop them in here for us, and we'll try to address them as we go along. We encourage that, and we'll have some time at the end. And I'll also add here our contact information is available on the slides and on the webinar information. And if you have questions that we don't address during the webinar, we encourage you to call or shoot us an email. We're happy to field those. And again, this is it's pretty new issues, so there may be some questions that we're hashing through ourselves and can't give you direct answers to, and it may just be that there are no direct answers. So welcome to the wonderful world of law. All right, so Skip, you want to give a little? I'll turn it over to you. You can talk about the folks that are some of the people that this is going to affect.
Well, there's three basic groups of folks or entities that these new laws and cases are going to be impacting. And you start with the disabled individuals. And the ADA has been around for a while, and it's generally had a very positive impact on disabled individuals and giving them access to facilities, typically brick and mortar in the past, that they may not have had before. Things that we're all familiar with, like the wheelchair ramps or the lifts into a swimming pool at a hotel. But the other folks that are going to be impacted by this are the companies that are doing business on the web, which is just about every business entity today. There is a split in the courts right now about whether you have to have a physical location or just a web presence. Brick and mortar is the physical location, and there does have to be a tie-in between the use of the website and gaining accessibility to the physical location. And the final group are website developers. If you look at most third-party vendor contracts with website developers, you'll see standard contractual language in there that says that their project will comply with existing rules, regulations, and law, whether it be state and federal level. So there's the possibility that for a website developer, if you're doing some websites for clients and it's not compatible with the ADA and it's not in compliance, you could have liability as well.
And if you have questions about that on the development side, contact us. There may be some ways now that we can sort of mitigate some of that. So background, ADA in the 21st century. Actually, I'm going to let Skip's done a lot of ADA cases in physical barriers and architectural issues involving hotels and other places of physical accommodation. So I'll let you keep running with some of this if you're good with it.
Sure. Let me start off with this for my own background. I've been a lawyer in Orlando since 1983. So when I started in law school and started practicing, we dictated into recordings and we had mimeograph paper. Today it's a different world, and this type of area in the internet is absolutely exploding. So we wanted to run some of the numbers by for you to give you a feel for what this is like. And we started with the overall federal lawsuits dealing with the ADA. From 2013 to 2017, they exploded from 2,700 cases to 7,700 cases. Part of that is because of the brick and mortar typical ADA cases, but another part of that are these cases dealing with federal website accessibility. In fact, Florida in 2017 had the second highest number of lawsuits, 1,500 in Florida. California was at the top with 2,700. Over a third of all the federal website accessibility lawsuits were filed in Florida. That's for nationwide. In fact, Florida is so progressive, if you want to call it that way, on these lawsuits. It had more than twice as many suits as the next 13 states combined. So we see this trend as just being astronomical, and it's really growing exponentially. And the reason why we wanted to present this to you is because it's important for what you're going to be doing in the future, because your legal exposure for the presence on the World Wide Web is growing larger if you're not compatible with the ADA.
Thank you, sir. And so how do we get here? I want to talk about a little bit of history and why this is becoming such a hot button issue right now. And it starts, in our view, with the Department of Justice. Back in 2010, the DOJ filed what's called an advance notice of proposed rulemaking. And so for the lawyers, actually even for the non-lawyers and some of the lawyers in the audience, what happens is you have law that derives from statutes, and then you have certain administrative agencies at the federal level that can create rules that help interpret those statutes. So you have the ADA, and the DOJ was tasked with creating a rule to deal with website compatibility in compliance with the ADA. And so the DOJ filed this advance notice of proposed rulemaking. It's a public record document. You can do a web search and pull it up, or if anybody's interested in looking at it, I can send you a copy. And what happened in that filing is the DOJ outlined several issues that they saw with the ability of folks with various disabilities to access websites, and proposed making a rule to provide guidance to businesses, and on the one hand guidance, and to encourage businesses to make their websites compliant, and probably a carrot and a stick. And there, along with that, oftentimes there's usually a fine or some type of enforcement action if you don't comply. Well, what happened from 2010? We went from 2010 to 2016, where the DOJ made a couple of updates with regard to that rule, but never actually created a rule. At one point, they broke it down into component parts. So under the ADA, you have Section 3 or Title 3 and Title 2. Title 3 deals with public accommodations such as hotels, restaurants, supermarkets, and so forth. And then the other sections deal with federal agencies. And so the DOJ split out and said, well, we're going to deal with Title 3 first. Well, and then 2016, as everyone knows, our administration changed over from the Obama administration to the Trump administration. And later in 2016, after the Trump administration came into office, the DOJ made an announcement that they were putting the brakes on any rulemaking. So they put it all on hold. And then just recently, on December 26th, 2017, while most of us were celebrating holidays with our family, the DOJ filed a notice and gave said that they were withdrawing the 2010 notice. And so they essentially said they're going to step out of this arena. And what's that mean? What that means for everybody now is that the courts are going to address this issue. And that's what we're seeing. We're seeing lawsuits, and more lawsuits are going to be filed. And we'll talk about this a little bit later. But one of the defenses that has been raised with some limited success was the fact that some businesses said, well, the DOJ is in charge of this, so I don't have to do anything until they make a rule. Well, that's gone. And now the courts are addressing it. We need to make you aware how you can protect yourself. And on the flip side, make folks who have one of these disability issues that they're dealing with this and coping with it aware of what their rights are and how you can enforce them. So, here's some examples we list here of some of the main issues. You have hearing, vision disabilities, either blind, low vision, color vision, and then in parentheses there's various ways that can be addressed through compliance, compatibility measures in websites and software. Deaf and hard of hearing, we have a couple cases. Actually, Harvard and MIT were sued for not having closed captioning on some lecture videos, is what I understand. Manual dexterity. Some folks can't use a mouse like the rest of us can, and they use a keyboard to navigate throughout the web, and so websites need to be keyboard accessible. Reading, intellectual issues, learning disability issues. Again, maybe low vision, low dexterity, folks who can't fill out forms and navigate through a site fast, can't get information typed in, can't read it fast enough to verify certain information. As you know, sometimes websites time out. If you're working on filling out a form and you've ever had to get up and go feed your kid or let your dog out or answer the door, and you come back and you're back to a blank field and you got to start over again, and it's frustrating. Think how frustrating that is for somebody who just doesn't have the physical ability to negotiate the information on that website in enough time before it times out. Here's another issue. This was not, some of these were addressed in the DOJ's original notice, but there's some others that have popped up, and one here is folks who deal with epileptic seizures. And my understanding is that flashing lights and certain graphics on a website can actually cause somebody to have a seizure episode, and so we need to make sure that those things can be adjusted to take that away or pause it. And finally, we put here letter G, some question marks, and that's simply because this is not, more than likely, this is not an all-encompassing list. I envision some creative technology person or lawyer or plaintiff coming up with some other issue that we'll need to deal with. But these are the main issues that we're aware of so far. And most of the lawsuits, all the lawsuits that we've seen, have dealt primarily with vision and hearing. So also, we'll talk about some of the standards. As I said earlier, when the DOJ split out Title III and Title II of the ADA, one of the reasons for that is because Title II deals with government entities, and we already have a Section 508 of the Rehabilitation Act that sets standards for federal agencies, and Section 504 deals with recipients of federal funding, so they already have requirements to comply. There's also the Air Carrier Access Act, which requires compliance. You'll see here a reference at the bottom to the World Wide Web Consortium. That's W3C is how it's known in short. And they have, this is a group of, a member group from various backgrounds and organizations, education, business, government, that has created what they call the Web Content Accessibility Guidelines. That's the WCAG, and they are now in version 2.0, and there is A, AA, and AAA at last that I looked at them. And these are different levels of accessibility. AAA might be 99% accessible, where AA is 90% accessible. And it has to do with the guidelines for websites being accessible with various screen readers. So Google has a screen reader, Apple has a screen reader, Microsoft has a screen reader. There's one called JAWS. There's a number of them out there, and the technology people will know them better than we do. But this W3C, WCAG guidelines, this is what the courts have been looking to. And so earlier today, actually, somebody asked me, so, well, what's the law say? What does the law require? And under the ADA, there is no requirement. What the ADA says is that you have to make reasonable accommodations to make your facilities accessible. And so, when the question comes up, well, what's a reasonable accommodation? This is a good standard to look at, but it's by no means, there's no law that says under the ADA you have to use this standard, but it seems to be where everybody's going. And the big case, the first case that went to trial is Gill v. WinnDixie, and this was a Florida case in 2017. And I'm going to let Skip give you a little background on Gill v. WinnDixie.
Let me start with the plaintiff in this case to give you an idea of the type of people that can be impacted by the websites. Gill was a resident of Miami for about 25 years, and he was visually impaired, legally blind, and had cerebral palsy. And he lived in an area of South Miami. He wore glasses that would protect his optic nerve and his eyes from foreign objects. He would use JAWS, what Eric had mentioned before, and some other software. And he would go to WinnDixie because of their low prices and because of the proximity to where he lived. But he also wanted to fill prescriptions there. And there was no accessibility notice on the WinnDixie website. Nothing mentioned any proposed changes that they would be making. And he wanted to fill his prescriptions online so he would not have to go to the store and orally announce to the person at the store filling the medications exactly what the medications were. And his idea was to protect his privacy under the HIPAA laws. He also went to other drug stores or stores that had that type of facility, like Publix and Walgreens. In each of their websites, he could use, because of the screen reader software that he had. He also went on federal websites and had no problem accessing those. So he sued WinnDixie. There was a couple-day non-jury trial, and WinnDixie said that they had set aside $250,000 to make its website accessible. That sounds like a lot of money and pretty scary, but let me tell you what the experts said. The experts said that there was no way that they would need to spend that much money. All they needed to do was to have an audit done. The audit would cost about $9,000, and then the company could fix all of its problems for $16,000 to $20,000. The idea was it would be $37,000 or less for a big company like WinnDixie to take care of all their website issues. What the court ended up doing was entering an injunction order, and the injunction order provided WinnDixie with a certain number of days in which to make sure that it had a web accessibility policy in place, to make sure that any third-party vendors who participate on its website would make sure it was fully accessible to anyone disabled. And they use the WCAG 2.0 criteria that Eric mentioned before as the benchmark to make sure that it was in compliance. And then they had to check to make sure that the accessibility was working. And if the plaintiff or somebody else felt that it was not, they were required to give WinnDixie some notice. WinnDixie could go in and correct the violation.
Yeah, let me add a couple of things here on this WinnDixie too. Is we talked just about the standards here, the WCAG standard, and one of the points that WinnDixie raised in the trial was they said they had redone their website in 2015 at a cost of $2 million. And wouldn't you like to have that contract, right? So they did the website at $2 million, and then a short while after that, they added some additional enhancements, the coupon feature and so forth, spent another $7 million. And they identified, and I may have, because the decision was 2017, I may have my timing off, but it was pretty shortly before the decision. And anyway, maybe it was 2015, but they identified several deficiencies as far as accessibility was concerned. But the person from WinnDixie testified that they were reviewing the various standards to try and figure out what to implement. And this is sort of one of these situations where what it appears, and we weren't involved in the case, but on the outside, it looks like they were just frozen by frozen in indecision. And so there's no legal standard that sets a requirement. And that brings us back to, well, what do we do? For us, the attorneys looking at this, we see everybody referring to the WC3, the Web Content Accessibility Guidelines. That's a good place to start, but by all means, do something. Don't do what WinnDixie did, which is just sit there and say, well, we set some money aside. They said they set $250,000 aside to make corrections and enhancements, and they never did anything. And I also want to point out here, well, when you talk about what's a reasonable accommodation, here's what the court had to say about the cost. And this seemed to be one of these issues that was probably, we can't tell from reading the decision, but reading between the lines when WinnDixie has somebody testify and say, well, it's $250,000, and then the plaintiff's expert says, well, we could do it for $37,000. The court says this, and this is a quote: "The court finds that whether the cost to modify the website is $250,000 or $37,000 is of no moment. Though the higher cost seems high, it pales in comparison with the $2 million WinnDixie spent in 2015 to open the website and the $7 million it spent in 2016 to remake the website for the Plenty program." That's the coupon program. So the court is basically telling WinnDixie, we don't care what the cost, if the cost was $250,000 or $37,000, you should have done something. And so WinnDixie gets ordered to comply, and then I have to pay attorney's fees, which I don't know what the final attorney's fees were. We may be able to look that up, but in a case like this that goes to trial, you're paying your own attorneys probably over $100,000, and then you're paying the other side's attorney's fees, which are probably over $100,000, plus their costs, which is their expert to come in and testify and for the work that he did. So that's a big reason why we're talking about this today. Now we want to talk about some of the other, and this is where we're going to start sort of hit some of the big broad points and not go in too much detail about the cases, except for this first one that we cite here. But these are some of the other issues that have been raised, some with some success in cases around the country. And this first one is this Gomez v. Bang & Olufsen. If anybody's familiar with, you may see B&O speakers. Apparently they sell exclusively online. And so B&O does not have a physical presence. And this is one of these splits of authority, depending on where the lawsuits occur and whether they're in state court or federal court, where one of the arguments that's been made is, well, the ADA applies to bricks and mortar, applies to a physical space, and it shouldn't apply to a website. Most courts have rejected that, but what the courts have seemed to come down on is saying that if you have a website that is linked to a physical accommodation, then you have to have that website be compliant. If you have a website that's a standalone and is not linked in any way to a physical location, some courts have said that you don't have to make the website compliant. And it turns out that the 11th Federal Circuit, that's the existing precedent as we know it right now. And the 11th Circuit encompasses the southwest portion of the southeast, portion of the United States, which includes Florida. Bang & Olufsen had a motion to dismiss granted. There's been other cases involving Netflix is one. So everybody knows Netflix is just a web company. Well, Netflix got sued and they made the same argument. Well, we don't have a physical space. We don't have to comply with the ADA. They lost. Blue Apron, I haven't used Blue Apron, but I understand it's a internet only food service or food delivery company. They did not have success with that argument, but it has seen some success in some locations. And that's why we say here that the courts are split. But let me touch on one other thing here with this issue. Go back to the Gill case, and Gill against WinnDixie raised 3 issues. And this is one of these things where we look at websites, and for instance, our law firm's website is really just informational. We don't provide any services. We don't give advice. We don't do anything. Our website is just simply a digital brochure. It's not an access point to anything. It's merely information for folks to jump on and look at on the web. But Gill said he wanted to try and refill prescriptions. He said he wanted to access coupons that were only available on the web. That was a big no-no for WinnDixie. But the third one was using the map feature, the Google map feature on the WinnDixie website to find the closest WinnDixie. And think about if you have a website or websites that you've seen how many people drop that Google Map feature onto the website. I know our law firm has it. And if that's a basis for saying that your website needs to be ADA compliant because you have the map feature on there, I think that where this is going is it's going to incorporate every website. So, other arguments here, mootness, this has been raised, and I'll hit this with res judicata. Res judicata is one of these fancy Latin words. I don't quite understand what it means, but you hear it in law school, and it has to do with that a court will not address issues between the same parties over the same issue in a subsequent case. When it's done between the people fighting, it's done. And so defendants who have been sued have raised this issue of res judicata and said, well, we've been sued in another case, or we've entered into a settlement in another case, or have an order from another case that already requires us to make our website compliant. So that should be res judicata, and it should be a basis to dismiss the current case. Well, it's not really. It's technically not correct, but it does support what's called a legal mootness argument, which is the current court. If we're sued here in Florida, for instance, and we've already been sued and we're under a court order in New York to bring our website into compliance, well, the current court isn't going to do anything that hasn't already been ordered by another court. And we'll touch on that a little bit later when we talk about remediation action. But that's seen some success. Finally, this last one, primary jurisdiction. That's an argument that has been raised and was raised once with some success, where one of the defendants said, several have raised it, but only one was successful that I've seen, where several defendants said, well, the DOJ has primary jurisdiction over this issue. They've already been tasked with creating a rule. They've already announced they're going to create a rule. And so there's no reason for this court to enter an order. We'll just wait to see what the DOJ has to say, and we'll be in compliance with the DOJ. Well, now, since the DOJ withdrew that rule in December, that's no longer even a potential defense.
Before you go on, Eric,
sure.
On the mootness issue, this is another one where there's been a split in the different courts around the country. Although in Florida, they seem to be pretty interested in this mootness argument. In Panda Express in 2018, a court in South Florida, federal court, found that a similar suit had been settled where Panda agreed to modify the website to ensure that a vision impaired person can access the website. And so they said the new suit was moot. Just a little earlier in 2017, Five Guys, the hamburger place, was a defendant, and the court found the claims were not moot because although Five Guys was in the process of updating accessibility, they had not successfully completed that project. So the case wasn't moot. But in 2017, two other Southern District courts in Florida, in Hooters and Outback, dismissed the case or found that the case was moot because there was a remedial plan in place. And which is why we think that some of the things we're going to suggest that you can do to limit liability later on has some viability because of those cases.
That's right. And so that's how we learn to defend these, is by reading what's happened and trying to pick up either what's been successful or why an argument wasn't successful and read the nuances from them. We got a question, actually. All right, and fire away, by the way, anybody who has questions out there. At what point is the website an extension? Marketing or offering content about the services, is that an extension? I think that probably a question popped up maybe when I was addressing it, and that was where, there's no bright line. It's a gray area. Again, even any service where it's just where you have essentially a digital brochure, I would argue that it's not a physical extension. But I think where this is going to go eventually, I think we're going to see that all websites are going to need to be compliant. And as a practical matter, sometimes it's just informational. But if you want to add a service, for instance, I say our website's just informational, but we've popped some videos and put some other things. We have all our webinars, prior webinars, and articles, which are informational, and we need to work on making sure that stuff is accessible to everybody. So I hope I addressed that. If you have further questions on that, please get with me offline. Oh yeah, okay. Skip actually points out, well, that's the 11th Circuit case where let me step back on that, because it's interesting, and I think this this is what happens with courts. So here's what the 11th Circuit says is, and this is, as I said, the 11th Circuit is the authority over Florida and other southeastern states. And the 11th Circuit said that the ADA does not require places of public accommodations to create full-service websites for disabled persons. In fact, the ADA doesn't require a place of public accommodation to have a website at all. All the ADA requires is if the retailer chooses to have a website, the website cannot impede a disabled person's full use and enjoyment of the bricks and mortar store. And frankly, I think that decision is flawed, because what the court seems to be saying there is you're not required to have a website, but if you have a website and it impedes access to the bricks and mortar store, you can get in trouble. Well, how does the website, as a practical matter, impede access to the store? Really, what's going on is you're creating enhancements for certain customers to access the store. Let's go back to the WinnDixie example with the coupons. You're creating more benefits for people, but you're not impeding access to the store. You're just creating an additional benefit. But then I would argue, isn't it the same thing that Netflix or Amazon or any other company that's entirely or primarily web-based? Isn't that what they do? Don't they create a service, a paid service or public service? They create some type of service online, and if you're not ADA compliant, then it's only available to a certain segment of the population. And we got another question here. It would seem even a brochure site with a hyperlink phone number that dials with a click could be considered interactive. Yeah, click to dial, it could be. And that's actually going to be almost a great segue into one of the points we're going to raise. What we've done on our website, if you look at the ForsterBowman.com, you'll see that we've got a notice on the home page that has a phone number. We don't have a click to call number, but we have the phone number to call for accessibility. But I think where this is moving is we're going. Do you think differently, Skip? I think it's going to where everybody's going to have to be accessible. So look at. Sorry. There we go. So what can it cost if you aren't in compliance? Well, one thing that's interesting here is the ADA. It's not like other laws where as long as you just stay home, keep your nose clean, you don't get in trouble. This actually requires businesses to take affirmative action. You have to go out and make changes. Oftentimes, as long as you're not out doing anything, you're not going to get yourself in trouble. But if you just pop a website up, people need to go back and take a look at this and see what kind of changes and adjustments they need to make. And if you get sued, what plaintiff hits your website, and we've seen, by the way, plaintiffs who've sued multiple businesses by the same plaintiff. We call them serial plaintiffs. We've also seen businesses get sued in multiple locations. So if you're a website, you're providing services all over the country. If you provide sales to customers in California, New York, and other places, you could get sued in all of those places all at once. You could have a suit filed in Florida, a different person sue you in New York, and now you've got a bunch of them. We've seen that happen. In New York and California, California has a state statute that allows plaintiffs to recover monetary damages. I think it's $4,000 in statutory damages in addition to attorney's fees. New York has a state law and, I understand, a municipal law in the city of New York that provides for monetary damages. Under the federal law, under the ADA, and usually the way those laws work when you have a state law is a violation of the federal law is also going to be a violation of the state law. And oftentimes the states, the way the law works is the states can't do something to minimize the effect of the federal law in general, but they can make the requirements more stringent. And that's what's happened here is California and New York are two states who said, not only are you going to be subject to a legal action to bring your site into compliance, but we're going to let the plaintiff collect money from you. And then finally, attorney's fees. If you are sued under the ADA and you have liability, then you're going to be obligated for the other side's attorney's fees. And that's usually the battleground issue here in these cases. And Skip knows much more. And Skip, you've dealt with that. What's your experience been with the attorney's fees issue in ADA cases?
Well, one of the reasons for the dramatic rise in ADA cases in general is because they've been driven by some plaintiffs' firms that do hardly any legal work except for bringing these cases. And they have what Eric described as serial plaintiffs, Some federal courts have described them as professional plaintiffs that will go on road trips and try to find different business entities that are not complying with the ADA. And then 30 days later, they'll have an expert report and file suit against every business entity that they found. And the business entity is going to have to comply with the ADA requirements. And as part of the settlement, the attorneys are looking for fees. So there are a lot of cases that are filed on these brick and mortar. What we're thinking is that this is going to be a new trend. And because now you don't have to get in the car and drive from South Florida to Central Florida looking for businesses that are violating the ADA. You can simply stay at home, go on your website, on the websites that are out there, and see who is not complying. And because most people don't know that compliance is mandatory, we think that there's going to be a big rush on lawsuits in the near future.
And we've seen a lot in South Florida, not in Central Florida, but we expect to see them here. So now you can sit home, scan the internet, and figure out who you're going to sue. So what do now we'll start talking about what action folks should start taking. So we've talked about the guidelines, and you can go read those. There's also folks that deal with website technology and web development may be familiar with those, and we know some folks who do that. You should probably, if you have a website, if you're an operator or an owner, engage an expert to conduct an assessment and find out what the status is of your website and your mobile app, by the way. And here's another one that people don't really think about. Lawyers, oftentimes, we become the last people invited to the party. And we understand people don't want to pay legal fees. Let's just go get an expert and see if we can fix this. Here's one where we're going to tell you that there's a distinct advantage to hiring counsel to be involved in this process from the beginning. And it's not that the lawyers are going to be conducting the test or reviewing your website or actually doing the work, and probably the cost is minimal. But when you hire your attorney and then and have your attorney engage the expert, what that does is it protects the results of that report behind the privilege of confidentiality that comes from attorney work product and attorney-client privilege. So, two scenarios. You hire an expert to go out and do an assessment, you get sued, and one of the discovery requests is, give us all communications with anybody that you've talked to about your website in the last 2 years. Now you got to hand over the roadmap for all the stuff wrong with your website. And what if you had the assessment done a year ago, but you can't afford to make all the changes and implement them all right away? Now you've got another argument for plaintiffs, as like in WinnDixie, you've known about this for 2 years now and you've done nothing. If you have your attorney involved in this process, you bring the counsel in early, the attorney gets the report. We're not, it's always subject to court discretion, but we're not going to hand that over. If we get asked for it, we're going to object and say that's all privileged. We're not turning anything over without a court order. And then finally, when you start engaging in this process, we're going to have you provide what's been referred to by the courts as a notice and accessibility banner, basically something on the website that says we're making changes and we're addressing these issues now. So defenses in a lawsuit, your potential, and this is again continuing on with lawsuit mitigation. If you're a business and you hire somebody to do work on your website, you want to require that your vendors comply with accessibility guidelines. So as Skip mentioned earlier, we see a lot of agreements that have a general term in there that represent and warrant that all work is done in compliance with all applicable laws and regulations. But we want to specifically address this issue because we know it's an issue where you have exposure. And
you could add to a contract with a third-party vendor an indemnification hold harmless provision, so that if you were sued and you were sued because the vendor did not make sure that it was compliant with the ADA, they would have liability and essentially reimburse you for the damages and attorney's fees that you've incurred.
That's right. And on the flip side, by the way, if you are a vendor that provides these services, it would behoove you to let your client know that this needs to be addressed. And there's additional cost for that. The reality is this is going to make things a little more expensive, but it's also going to create some work and some business. And if we're representing a vendor, we may want to put some limitation there, say, well, we'll comply with all laws and regulations, except we've made you aware of the fact, put that in the contract. We've let you know that ADA compliance is an issue. You've opted not to have us ensure and warrant full compliance, so that's carved out. Or we can limit your liability to, a certain percentage of fees. There's all kinds of ways you can negotiate that for the benefit of the vendor or for the benefit of the customer. But it's something that you need to be aware of and you need to address. So, we talked about this curing notice. I mean, obviously you want to start working on this, but what do you do in the meantime? What if you're in a situation where it's going to take you a while to implement all of the changes? And we've seen some success, and this was referenced in the Gill case. So during that Gill case against WinnDixie, the court made notice that, noted in that lawsuit decision that WinnDixie had didn't put any notice on their website, that other businesses put a banner or put a notice on their website to address compliance issues and at least make people aware of the fact that they were addressing these issues. WinnDixie, even though they had identified a problem, again, they had this, they had $250,000 set aside, identified an issue, but they didn't put any notice. They didn't tell anybody that they were working on it. Would that have carried the day in that case? That we don't know. But for now, there's one case where a business was successful, and it's interesting that they were actually back-to-back pizza shops that were sued. Pizza shops and businesses, and it was Yum Brands, which is Pizza Hut, and Domino's. And Domino's was successful on a motion to dismiss an ADA claim because they had a banner on their homepage that included a notice that they, for anybody that was having trouble accessing any of the features on the website, there was a phone number to call, and you could call the phone number, get a live person, and receive all of the services that would otherwise be available on the website. And the court seemed pretty impressed with that.
Here's what it said. I have the case in front of me. If you are using a screen reader and are having problems using the website, please call an 800 number for assistance. And the court noted that this number was staffed by a live representative who can provide blind or visually impaired individuals with assistance using the websites.
So that's, I mean, that kind of, Domino's filed a motion to dismiss the plaintiff's complaint that was successful. And so that gives us one example of something that you can do now to reduce your risk of being sued or reduce your possible downside if you are sued while you're getting into compliance. Now, Domino's had that number staffed with a live person. If you have a website, for instance, where you sell stuff online, we put some other points here. So you want to have the phone number that's available, have it manned by a live person. We put a note here, 24-hour or as close as possible. In Domino's case, what good would it be to have a phone number answered at 2 o'clock in the morning? Nobody's delivering pizzas at that hour, so they probably didn't need that. But I think this is one of these ones where it's a judgment call, and on case by case, you may want to have as close to 24-hour access or an answering service as possible. These are best practices. So what I would tell a client is, I'm going to advise you to do 24-hour access until you get the website compliant, with the understanding that a lot of people, it's just, businesses, it's not practical to do that either because they don't have the staff, the manpower, it's the cost. And then we would go back to the ADA's requirement that you make reasonable accommodations. So we put 24-hour, but it's a do your best. And then you want to make all the products and services that are available through the website available via that phone number. And then finally, a point that would seem almost so obvious it could escape notice is make sure that that banner page, that information at the very least is accessible. Doesn't do you any good to put all that information up there for somebody who can't access your website and give them an alternative, but they can't access the information in that alternative because that page is not ADA accessible. So you start with that page, you put all the information up there, and then work off of that. Let's see, I got another question here. Somebody asks, a couple questions. Let's hit these. This is fun. Do you think that including a notice on the website that compliance work is being done encourages a visitor to initiate a lawsuit? No. I mean, if somebody's looking for a lawsuit, I think they're looking for a lawsuit. As Skip said, you go back to the analogy of the folks that are driving around looking for it. I think putting a notice on the web page discourages a lawsuit, because if you have that notice there, remember, you got to go get an attorney to take one of these cases. And if it's an attorney who's familiar with the issues and has been looking at this, they're going to see, okay, well, what makes you come to me? Well, they've got a notice up that the website's being, the website's getting work done to be compliant, but it's not right now, so let's go sue them. If I'm the attorney, I'm not real excited about that case.
And having a notice may help you if they decide to take the case and file it with the court, because they know that you're processing and trying to remedy the problem.
Now, again, going back to reasonableness, what if you go on and you see that notice and you know that, and then you go on a year later and that notice is still up there, and you're like, well, wait a minute, you had that notice up in 2016 and 2017, you still got that stupid notice up there on the site. Now you maybe have an issue. So I wouldn't hang your hat on just having that notice. Although I would say that one of the things that's been noted, and it was noted in the Domino's case, was that the DOJ does say that you can have alternatives. There's a DOJ directive, or DOJ, it's not law, but it's a what we would call persuasive legal authority, where the DOJ has issued a notice that says if you're not accessible, you can have reasonable alternatives. I wouldn't hang my hat on that for the long term either. I would just work towards accessibility and have the phone number up in the meantime. Let's see, another question here. Are you sure? Oh, wow, we got a lot of questions. Okay, so are you sure that you can limit notice? Excuse me. Are you sure you can limit liability? Building contractors cannot limit liability if a new building owner tells a contractor not to build a bathroom ADA. This is a different issue because it's so new. So we wouldn't advise you to build a website. You're right. We're not going to have nobody's going to get away with building a building that's not ADA compliant and then sticking notices up and escape liability. What this is mitigation. This is the best we can do right now. So rather than sit here and tell you, well, this is coming, the wave of litigation is coming, we got no answers for you. What we're saying is, look, everybody that has if you're doing a new website, make it compliant. But if you have a website now and you're already up and published on the web, and now you're listening to this seminar saying, good grief, what am I going to do? This is what you're going to do. It's mitigation. It's certainly not going to, I wouldn't advise anybody to do a new website and then put these notices up and then just sit on those notices. You need to get to work. Because if you're sued, that's one of the things that may come up. Say, okay, when did you put the notice up? You put it up November of 2017. Okay, what have you done since then? Nothing? That's not going to look good. And let's see, we have another question here on an address. And a few of them.
There's a lot of questions.
Yeah, seems like most of the companies that sue are deep pocket companies. Do you believe smaller companies can get by until such time the WordPress and other CMS come out with additional plugins? You're right. I mean, consider what's being, that's a great question. Who are the targets here? I think everybody's a target, but smaller businesses don't have the target on their back like a big company does. But you got to find balance as well. So, the plaintiff's lawyers want to collect their attorney's fees, so they're not going to want to sue a mom and pop shop that we're suing them might put them out of business. But if you take a reasonably successful business, a small business here in Central Florida, maybe a small community bank, a little somebody that has, a client that does maybe $1 million a year in revenue in sales, they might be your ideal target. And the reason why is that, a plaintiff's lawyer that doesn't really want to work, doesn't really want to go to trial, just wants to get a quick payment, they may not sue Publix or WinnDixie or a big corporation, Lockheed Martin, because that company is going to lawyer up and provide a defense and may make it difficult. Where your smaller companies sometimes may not, they may not even go get an attorney. They may just not defend very well and be more apt to pay more quickly. What do you think, Skip?
I think that's true if the lawsuits are being motivated by the plaintiff's lawyers trying to collect attorney's fees. But in brick and mortar ADA cases, we've had several in the office in the last couple of months One was representing a small business owner that had a hotel. Another one was representing a tenant in a shopping center where just about everyone in the shopping center was sued by the plaintiff's lawyer for ADA violations. So those are relatively small businesses that had to deal with the problem, have everything corrected, and as part of the settlement, pay attorney's fees to the plaintiff's lawyer. And usually with the brick and mortar cases, and I think the same thing will be true with these internet cases, is that you want to try and get it resolved as quickly, as efficiently, and as inexpensively as possible, which would include as inexpensively for the payment of your fees and the payment of the plaintiff's attorney's fees.
So I've got a couple more questions. I am going to come to those. We may answer them here in the next slide or two. I want to make sure we provide you all the information, for what you can do now. So we told you about the website, start to work on compliance, get the notice up. If you happen to be sued, or if you know someone who is sued, is it what do you do then? You just say, okay, well, too bad, I didn't make it. Now I'm going to get pounded with, $100,000 in attorney's fees like WinnDixie did. And ironically, they filed bankruptcy or gave notice of filing bankruptcy about a week later. Actually, it wasn't a week, it was a couple months, but just recently. No, there's actually some things that we think you can do here. Looking at some of the defenses that have worked, the primary jurisdiction, that's gone. We talked about that because the DOJ is not working on this anymore. The physical space, whether you're a physical bricks and mortar location, I don't like that defense, but it's a defense you can raise. If you only do business on the internet and you're in the 11th, where we are in Florida, I guess in federal court, that defense is still a valid defense. So if you don't have a bricks and mortar location, then that's a potential defense. And then
but we think that's going to go away.
Yeah, we think that's going away. And so, mootness, res judicata, we talked about earlier, but mootness, that relates to the top note here. If sued, or we say enter into a settlement, a consent decree, a judgment. The reason for that, and we touched on this earlier, is that if you're sued, for instance, you can even be sued twice. There's companies that have been sued twice, I think, in the same state. So you get sued here in Central Florida, and you do business all over the country. Now you get notice you've just been sued in South Florida, and you've been sued in New York, and you've been sued in Utah, which happens to be like number 4 or 5 in ADA suits. Yeah, you're being sued on several fronts. Well, what we would recommend if we're representing a defendant, what we're going to do is we're going to try and immediately get something down, either a settlement agreement or that's approved by the court. And a lot of people want to make settlement agreements confidential, but here's what we want to do. We want to get something that's got the court's stamp on it, either a court-approved settlement, a consent judgment, something that outlines your requirements to bring your site into compliance. So it's an order similar to what was in WinnDixie, what the court ordered, but we want to voluntarily enter into some type of order that says we're going to bring the site into compliance, and here's the time we're going to do it within the time frames. And right there, then now you've stopped the legal issue, and what that does, it shuts off the fees. And the benefit of having that be public and not confidential, and this is the mootness argument, is now if you get sued in another court in a state or in another state, you can go there and say, hey, we're already under a court order that's mandated that we have to make certain changes by a certain time frame. And there's nothing that this court is going to do that's going to, you're not going to improve upon that. All they're seeking in this case, all the plaintiff in California is seeking, is the same remedy that the plaintiff in Florida is already getting for all plaintiffs' benefits, and that is a remedy to the website. And so that's why we advise doing that. And it's really, if you get sued, you got to talk to a lawyer right away, because that meter is going to be running for the attorney's fees, and what you want to do is shut that meter off. And then one of our questions, this one I want to come back to this, and if you have questions about that, just contact Skip or I, feel free to reach out. But standing, another defense that's been raised is standing. You actually have to be affected by it. So somebody makes the question, does one actually have to be disabled in order to sue? And what's keeping the lawyers from going around suing everybody? Wow, it's good to be a lawyer these days. No, that's a great question. You do have to be affected by it. You have to be damaged. That's right. So Skip hits the word. Is you have to have some damages. And there was one case where somebody raised that, and they couldn't show that they actually went to the website and tried to access certain services. So there, the lawyers probably got a plaintiff, and they had maybe a disabled plaintiff, and the disabled plaintiff has testified, and somewhere along the line they were asked about accessing certain services, and they couldn't testify that they did. They had no standing. And so if you're not disabled, if you don't have a vision impairment and you sue because the site is not screen reader compatible, you are not going to have standing, and that will be a defense. And so some of these, this is just, we're wrapping up here, and I want to be able to get the rest of the, there's a couple more questions. We started a couple minutes late, so we'll let this run for a couple minutes after 1 o'clock, but we understand that people may have to jump off at the end of the lunch hour, so we won't be offended. There's want to point out just some other random issues that pop up here. Several states require websites, sometimes government websites or even private ones, to have a privacy policy. California and Nevada require privacy policies. There are other states that do. So if you're required to have a privacy policy on the website, you've got to incorporate, you've got to make these privacy policies accessible to screen readers and other technology that provides access. Third-party vendor issues we've talked about here. If you're doing work on a website, you want to make sure you address this issue on the front side of any work that you're doing. You can maybe get a carve out. And then on the other side, if you are a business that gets sued and the allegation is that your website's not compatible or compliant with the ADA, and if we're representing that business, we may go back and say, well, who did your website work? And we'll look at the contract, and if the contract has a provision in there that says that the company doing the work warrants and represents that the work will be legally compliant, we may end up giving notice to that company that they owe you indemnity coverage. They basically have to provide a defense for you because they have violated that representation and warranty in the contract. Privilege we talked about a little earlier. Skip, anything you would add on there?
I think it's a huge advantage to work through counsel, because this law is going to continue to develop, so your counsel is going to be keeping up to date on the latest developments, but being able to have confidentiality, particularly when you're working with a vendor or expert to bring it into compliance, could be very advantageous down the road in any litigation.
We got another question here. This is a good question. Somebody says, if a website offers an e-commerce link provided by a third party, should you limit your compliance action notice to only the website you have control over? Yeah, your website should be limited. Your notice is only to what you have control over. But it raises another interesting point is, well, what if you incorporate, if you have add-ins or you have something on your website or you're tied to a third party and they're not compliant, do you have liability? That's an unanswered question. I don't see why you would, and Skip is shaking his head no, or maybe no. Maybe if you know they're not compliant and you invite them onto your website, then possibly yes. We haven't seen that case. It may be out there. That's a great question. If you can only control what you can control, but I guess the issue there is that you can control what third parties you bring onto your site. Most, like Google, the Google Maps feature, I know this did come up in Gill, is they said, well, we bring on Google Maps, we don't control that. Well, Google Maps apparently is compliant. So when you incorporate it onto your website, it's already in a compliant, it already has compliant status. So you need to make sure you don't alter that.
In the Gill case, the court actually found that all the main internet browsers, such as Google Chrome, Internet Explorer, and Safari, already comply with the WCAG guidelines.
Yeah, I gotta think. I haven't looked. I know a lot of people are checking these out, and some of our technology people out there are probably go looking around. I'm curious about some of the big sites, competitors to Netflix and Amazon and Walmart's online site and so forth. But I think most of the big players are probably coming into compliance. I think most of it's going to affect medium size. So that's most of the issues. One other thing we want to touch on, just make you aware of today, is there is actually a pending law. It's House of Representatives Bill 620 that addresses ADA legal issues. And it's a proposed law. It's gotten through early stages of the House right now, but it's still a ways from being a law if it ever does get passed. And what it does is, one of the main things and how it would affect what we're talking about today is it provides a pre-suit notice requirement, which is probably a good idea. So it says a plaintiff can't sue unless they first give notice to the business, and the business then, if they don't address those issues in writing, then the business can be sued. So it gives you an opportunity to actually have a plaintiff, which is probably the right answer, have a plaintiff address these issues first before they sue. But there's some weird language in it actually, and if anybody has an opinion, want to shoot me an email on this, I'd love to see it. The bill, what it says is it prohibits civil actions based on the failure to remove an architectural barrier to access into an existing public accommodation unless, and then there's this written notice requirement. So the question that I have on this is, well, what is an architectural barrier to access as it's described in this proposed law? Is the architectural barrier a physical barrier, bricks and mortar? Because in the technology world, we refer to software architecture and website architecture. So does architecture apply to websites? It was interesting, we had Tony Peasy. I'll give a shout out to Tony because he does this work and has been looking at this, has been very helpful for us in looking at the technology issues on the compliance side. And when Tony and I were talking about it, I'm the lawyer, I look at it, I say, I don't think architectural barrier means websites. But then Tony, who's in the technology world all the time and uses that term differently, says, I think architectural barrier does apply to websites. I don't know. If anybody has an opinion on that, let us know. But that's a law that's out there. A couple more questions. Good, we have questions. We'll keep it going here. Does one have to be able to say, okay. WCAG, the Web Content Accessibility Guidelines has 3 levels. How would you know which level you are legally obligated to comply with? We touched on that a little bit earlier. We don't know. That's the short answer is we don't know, because remember, WCAG, that's not the law. That's just what the courts have been looking at to say is reasonable. WinnDixie, I think, was WCAG 2.0 AA, but now I know there's a WCAG 2.0 AAA. I don't know how long that's been out. Usually, in this context, I think what's going to happen is what's reasonable today may not be what's reasonable in 2 years, right? So as the technology continues to develop, you're going to have to stay on top of this. It's probably good news for our web development community because it's probably going to create, it's just like law. We do, people, when they come to lawyers, they want, give us a standard employee agreement or a contract or a software contract. And they just want one form that they can fill out. But what we always have to tell people is, look, this may work for a little while, but you should take a look at this every 6 months to a year. Let's see if any laws have changed. Let's see if there's anything that we need to update. Because there may be something, a case that came out that now says, okay, this is not going to work where we thought this was going to work last year. And I would say on the websites, it's the same thing. You got to have somebody to either have good knowledge of this or have somebody you're working with that you trust, because we don't know what the level is. I understand those levels have to do with a percentage of compliance, and it could be just what you're able to convince the court is reasonable. It may have to do with cost. There's lots of issues that could come into play there. You could be, if you have a website that, if you're a small business and you spent, your website was $10,000 and you spend, $500 a month on website, work and updating and SEO and your email marketing campaign, and your budget is under $1,000, and it costs you, to reach one level of compliance, it costs you $20,000, but to reach a higher level of compliance, it costs you $200,000. It may just be that it's not reasonable to spend $200,000 for a small business like that. So these are fact-specific questions that go on a case-by-case basis. And what happens as a practical matter in court is we would go out, if we're either on a plaintiff's side or a defendant's side, and we're agnostic, we would be on either side here. But we would go out and if you're not compliant, you've been warned, you're compliant. But we represent companies and businesses. But I don't want to take sides. And Skip kind of looked at me strange. But we would go out and go get an expert, and somebody on the technology side who would be our expert would testify, this is what's reasonable and this is what should be done. I hope that's and go ahead, you want to add to that, Skip?
And the experts that we have been using in your brick and mortar ADA are not probably the experts that we're going to be using now, because now it's going to be web developers and software developers. I did want to point out that in the WinnDixie injunction, the court said that every year WinnDixie needed to go back and deal with whether it was conforming and whether people knew what needed to have conformed. And then every quarter, they were supposed to make sure that they were in compliance. So as things change, I think Eric's spot on, that you need to keep yourself abreast of what the changes have occurred. There'll be more cases that'll come out. Sooner or later, the legislature and the president are going to sign off on some bill probably that's going to deal with this, that may change how this happens as well.
And that's going to, I think, wrap us up. Somebody says the bill passed, the 620 passed the House, but it has not become law.
Yeah.
So it's still got to go to the Senate, and it has to go to the president, be signed off. Yeah, and that's actually, I know who sent that question there, and much more knowledgeable than I am on that issue probably. So thank you for that. So yeah, so I think I said parts of it passed. So the bill has gotten past the House, but it's still a ways to go. And I'd be interested, the person who sent me that question, on your thoughts, if you think that architectural barrier would refer to a website. So thank you for that clarification and that point. With that, we are a little over an hour here. If you want to use this for CPE credit, you're continuing to get credit for our CPAs in the audience, or for CLE credit for any lawyers in the audience. We'll have documentation for that. We can send you a copy of the slides if you'd like a copy. We don't have a CLE number for this one, but Lisa in our office knows how to do the quick form to get you CLE credit. Thank you very much for joining us today. And if you like this one, we're going to do a deep dive into some of the cases that we didn't maybe call out by name, or some of the issues. We'll talk a little bit more about the DOJ issue, and then this pending law and some more issues on that, and some of the different sides on 620. And that's one of the things that we can address next month. And if you like this and you want to hear more about an issue for next month, we're still developing those details. So by all means, give us a call or shoot an email over here, and we'll try and cover that issue in more detail. Skip, anything else that you?
I want to thank everybody for the opportunity to spend some time with you this afternoon, and also thank you for the questions, because there were some great questions and they help us in the presentation very much. So we thank you.
All right. Have a great rest of your day.